Today, as promised, I'm supposed to talk about the first article of the Constitution. You may recollect we have completed the preamble of the Constitution. However, having seen or heard of the Supreme Court judgment in disqualification of Telangana MLA's case, I am tempted to bring to your notice the constitutional issues involved in that case. Honorable Supreme Court directed the Speaker of Telangana Assembly to take decision within 3 months from the date of the judgment. You may be aware of the antecedents of this case. In 2023 elections, Congress party has come to power with slender majority. Out of 119 seats in the assembly, Congress party got about 64 seats. About 10 MLAs have defected from TRS party to the Congress party. Consequently, an MLA, Mr. Padi Kaushik Reddy, and some other, has filed writ petitions in the Honorable High Court for the state of Telangana, which were dismissed. Later, they have filed writ appeals in the Supreme Court. Of course, K.T. Ramarao has also filed a writ petition in the Supreme Court. Today, the Honorable Supreme Court directed that the Telangana State Assembly Speaker should take decision within 3 months from the date of order of the Supreme Court. As a student of Constitution, or rather as a researcher of the Constitution, being a writer of a book titled Indian Politics versus Indian Constitution, my heart burns. I am tempted to come before you with certain clarifications. This anti-defection law was introduced by 52nd Constitutional Amendment of 1985 during the tenure of late Sri Rajiv Gandhi. In the governments, there was insecurity, and the governments could fall or change any moment due to coalition governments and defections. As a measure to curtail such happenings, this Amendment 52 was introduced in 1985. According to that amendment, any person defecting from his parent party to the other party will lose his membership. Only exemption is given that if 1/3 of the political party defects to other party, such disqualification does not apply. So ultimately, this law, instead of being an anti-defection law, it has become wholesale defection encouragement law. In fact, if 1 or 2 persons defect from one party to the other, nothing would happen. As stipulated, if 1/3 of the party goes into another party, sometimes the governments may fall and the opposition may become a ruling party. This is a very dangerous situation. Immoral thing or irregular thing is conducted by a legislator, a member, but the punishment is given to the people of that constituency and people of this country. People of that constituency lose their representative, and the country loses thousands of crores of rupees to conduct midterm elections. Because if one party is likely to lose power, what does he do? He recommends for dissolution of the parliament, Lok Sabha or the assembly. So midterm elections would ensue. That is a great cost on the exchequer. While passing this anti-defection bill, a clause was introduced that the decision of the speaker shall be treated as proceedings of the legislatures. The power to disqualify the defecting members is given to the speaker. But this is an illegal or unconstitutional thing they did. Because it is the power of the president and the governors to take oath from the members and to decide their disqualifications under Article 103 and 192. Of course, on the advice of the Election Commission. How Parliament can remove the rights of the President and will entrust to Speaker? Speaker is not an independent person. He is an entrusted person. If somebody is coming into his own party, he will protect them. If somebody is going out of his parent party, he will disqualify them. So, it is a flaw in the law. And moreover, please consider Article 122 and 211. 122 refers to the parliament proceedings and 211 refers to the assembly proceedings. In these proceedings, courts are prohibited from interfering even if there are procedural errors. Needless to say, if there are no procedural errors, it only means that on whatsoever count, judiciary is not supposed to interfere with the legislative proceedings. Legislative proceedings, we cannot equate with decision of the speaker which is made sitting in his chamber. Such a decision is not discussed in the legislatures. Legislative proceedings are discussed by all the members of the legislatures. But whereas a speaker taking a decision sitting in his chamber cannot be equated with legislative proceedings. This is another flaw in the act. Surprisingly, speaker is not exempt from this anti-defection law, which is included in Schedule 10 of the Constitution. Speaker himself is subject to disqualification if he defects from one party to the other. As such a power of disqualifying the defecting members should have not been given to the speaker. Now, the Honorable Supreme Court has directed the speaker to take decision within 3 months. Supposing he doesn't take, despite the instructions of the Supreme Court, directions of the Supreme Court, supposing the speaker does not take action, what will happen? The court cannot take any action against the speaker. As such, the Honorable Court ought not to have passed such orders. In Telangana, we have witnessed during the time of KCR Chief Minister, RTC employees participated in a strike. The government employed private persons and private buses and never bothered about the RTC employees to call for discussions. Instead, it was declared that all of them were dismissed. They went to the Honorable High Court. Despite the Honorable High Court directions, KCR steadfast said, what does the High Court do? I don't have money. This way, this kind of infractious, unenforceable orders ought not to have been passed. Anti-defection law itself is defective. It is, instead of anti-defection, it is wholesale defection encouragement law, whereby governments will fall. Midterm elections may come, by-elections may come. It is all, in fact, a havoc for the country. I hope I made it clear, especially this issue of anti-defection law and directions of the Supreme Court to the Speaker. Thank you for watching this video. I request you to kindly subscribe, share and comment on my videos. Our endeavor shall be to spread the constitutional message to the whole country. Thank you very much.